Welcome back, everyone. Today we're breaking down two wild courtroom showdowns featuring self-proclaimed sovereign citizens, or as they prefer, non-14th Amendment citizens. First up, a jaw-dropping case out of Colorado, followed by a much-requested follow-up from Michigan. Let's jump right in.
And court calls People versus Robert Geese, 26T884. And if you'll come on up to the podium. He appears in the courtroom, and the district attorney, Mr. McGraw, appears for the people. So, Mr. Geese, are you going to be hiring a private attorney? Do you want a referral to the public defender, or are you going to be representing yourself?
Your Honor, do I have standing to speak?
Yes.
I appreciate that. It's important to me that I stay respectful. I come in peace as a non-belligerent. I would like to read this into the record, if I may.
Sure, go ahead.
First, Your Honor, respectfully, for and on the record, I am Robert Eugene Geese, a man of the Union, a natural person, as said, a non-belligerent or enemy of the state, and I occupy the office of executor and co-trustee for the Noli Me Calcari Express Trust. I am here propria persona in that regard by special appearance only, not generally. Further, I am of the age of majority by both age and averment sui juris on the record in Weld County. I deny that I am a U.S. citizen, nor do I claim to be a sovereign. I deny that I'm a federal 14th Amendment citizen, a corporation, or a statutory person. I'm a natural, freeborn national of the territory of Colorado, known as a Coloradan. If I may, I would like the court to take judicial notice that the written record thus far is incorrect. As said, I am here propria persona. I am not here pro se, nor am I here pro per. It's important that that be documented and on the record. I have submitted a motion of discovery and an affidavit of truth. Has the court received and reviewed those documents?
If you want to request discovery, you need to do that through the district attorney's office.
I've done that.
Okay.
And the documents are recorded. Sir, did you?
I have received your request for discovery. It is being processed at this time, sir.
Okay. With that in mind, I don't know how this court can proceed without the affidavit being rebutted, answered, and discovery being taken care of.
That's not how this works. So the court is not the one that goes through the discovery. If you want to talk to the DA regarding plea offers in the case, I'm happy to set it over for you to do that. If you're going to hire a private attorney, or if you want a referral to the public defender, I'm happy to set another day for you to get that done as well.
Would you like to discuss the matter now, sir?
We can, sir.
Okay.
We would pass the case and then speak off.
Okay, we'll pass the case for a few minutes.
Thank you.
After a brief recess to weigh a potential plea deal, the self-styled non-citizen predictably waves it off without a second thought, and within minutes everyone files back into the courtroom as the hearing picks up right where it left off. Only this time, the tension is noticeably thicker.
If you would like to recall Mr. Geis when you have a chance.
Okay, sure. Court will recall People versus Robert Geis, 26T884.
And if I may correct the court, the last name is pronounced Geese.
Geese, sorry about that.
As in Canada Geese. Yep, that's okay.
Okay. Mr. McGraw?
Yes, after speaking with Mr. Geis, I advised him of the offer on the case. It is his plan to plead not guilty and set for trial today, Your Honor.
Okay.
Well, if I may,
I apologize.
respectfully, I do not plea. I don't know how I can plea. And I object to and would not consent to a plea being made for me.
Okay, so how do you want to proceed?
Well, we'll go ahead with setting up a trial.
So if you want a trial, that means that I will be entering a not guilty plea.
I understand that. I respect that. I will object to it, and I don't consent to it, but let's proceed.
All right, so I need to go through an advisement with you regarding your right to counsel. Do you understand that you have the right to be represented by counsel in your case?
Yes.
Do you understand that if you cannot afford an attorney, one would be provided to you free of charge if you qualify financially for the public defender?
I am here propria persona.
Do you understand that the charges against you in this case are driving under a revoked license and careless driving? They're both class 2, the careless driving is a class 2 misdemeanor traffic offense that carries up to 10 days to 90 days in the county jail. The driving under revoked license is as a class A traffic infraction and carries a possible fine. Are you under the influence of any medication, drugs, or alcohol that would affect your ability to think clearly?
No.
Do you wish to consult with the public defender before you make a decision to waive your right to an attorney and represent yourself?
No, I do not, and I do not waive my right to trial by jury.
Have you ever studied law?
I don't know how that is relevant to the case, Your Honor.
I'm trying to make sure that you're knowingly, voluntarily, and intelligently waiving your right to counsel.
I am.
Have you ever represented yourself in a criminal action?
I have.
Do you understand that you have the right to remain silent and anything that you say can be used against you in court?
And I choose the fifth. I won't answer any more questions.
To be clear, the judge isn't weighing your guilt or innocence at this stage. Her sole focus is confirming that you genuinely grasp the gravity of self-representation and possess the mental competence to handle it. This safeguard exists to protect your Sixth Amendment rights from being compromised. So ironically, attempting to plead the fifth during a FARETA hearing can actually backfire, prompting the court to step in and appoint counsel on your behalf.
Do you understand that you have the right to confront the witnesses against you and cross-examine them?
Absolutely.
Do you understand that you have the right to have witnesses that you choose be compelled to appear and testify on your behalf?
Yes.
Do you know how to request the witnesses be compelled to appear on your behalf? To subpoena them.
If you're asking whether I know administrative procedure, I wonder, Your Honor, is this a court of equity or is this an administrative court?
So do you understand that if you represent yourself, you're on your own? I can't tell you or even advise you how you should try your case.
I am here propria persona.
You know that you have the right to represent yourself, but by doing so, you could take a great risk of not properly presenting your case. Do you understand that you will be required to abide by the Colorado Rules of Evidence and the Colorado Rules of Criminal Procedure? And do you understand the defenses to the offenses by which you're charged? Do you understand that an attorney would be familiar with defenses and requirements to raise such defenses on your behalf? Do you understand that you must proceed by calling witnesses and asking them questions, not arguing or making speeches, but asking appropriate questions, and that you will not be permitted to tell the jury matters that you wish for them to consider as evidence during the examination of other witnesses? Do you understand that it would be much easier for an attorney to contact potential witnesses, gather information, and question witnesses, and to present your case than it would be for you? All right, at this point, I'm going to find that you are aware of the rights that you have and that you're giving up by waiving your right to counsel. You are not choosing to cooperate with the process. But at this point, the court's going to find that you've knowingly, voluntarily, and intelligently waived your right to counsel. We'll go ahead and enter a not guilty plea and get the case set for trial.
I object, Your Honor.
You're the one that asked me to set it for a trial. If you don't want it set for trial, I'm happy to set it for something else. Do you still want it set for a jury trial?
Yes.
Okay. That includes a not guilty plea.
Well, let the record show that I have not entered a plea, that the plea was made for me.
Let the record also reflect that the defendant's grasp of basic legal procedure is, to put it diplomatically, severely lacking, bordering on willfully oblivious.
You're asking for me to set it for a jury trial. That requires the entry of a not guilty plea. So the court will receive a not guilty plea today. I'll find that speedy trial runs on October 3rd. I'll order that motions be filed on or before May 4th. That'll also be the deadline for endorsement of witnesses and defenses. We'll set a half-hour motions hearing, trial readiness, and jury trial dates. And let's see what dates we have.
Motions hearing at 3:30.
Okay, June 15th at 3:30 for motions.
Trial will be July 29th.
Okay, July 29th at 8 o'clock for jury trial. Okay, July 14th at 11 o'clock for trial readiness. Trial readiness will be the last day the court will accept any plea agreements in the case. The court will issue a written pretrial order, and we'll print an extra copy for you today so you have those. Be sure to look because there are some additional deadlines and information in there about doing jury instructions and things like that. All right. Thank you very much.
Thank you, Your Honor.
And that wraps up our first case. Our self-appointed legal scholar is apparently ready to go toe-to-toe with the infinite wisdom of the universe. And you can bet I'll keep you posted as this saga unfolds. Now, shifting gears to our next sovereign citizen mastermind. This one's a follow-up to a case I broke down not too long ago. This time, he strolls into court with his wife by his side. And spoiler alert, she appears to be every bit as committed to the same questionable philosophy as he is.
Next is the People versus Philip Andrew Leffers. This is case number 26819FY. Ms. Dull appears on behalf of the people. Mr. Leffers appears in the courtroom but refuses to enter the well. I do remember this from the last time we were here last week. The court had removed the attorney of record and indicated that it would have a new attorney appointed. Mr. Leffers, that has not happened yet. We're still waiting for an attorney to be appointed for you, just so you're aware of that. All right?
Your Honor, is the court going to set the probable cause conference to next week?
We will, but it looks like Mr. Leffers is digging through some stuff here. What do you have, Mr. Leffers?
Well, I should go through that.
Mr. Leffers, before you start, I gave you a lot of time last week, so I'm not going to give you very much time this week. So if you're planning on giving the court a history lesson in maritime law or self-governance or any of that, I'm not going to have that today, okay?
So I have to stand up for my rights, otherwise my rights are forfeited by my subjection, and I will not do that. Your Honor, are we on the public record?
We are.
Is this a court of common law or admiralty law?
Mr. Leffers, I am not doing this today. I've already told you that. We're not going to go through this.
I move the court to take judicial notice of your oath of office to the Michigan Constitution as ratified without subsequent amendments under the United States Constitution. What say you, sir?
I addressed you last week about about the oath I took. I confirmed that you had a copy of my oath. I confirmed that.
Thank you. Your Honor, moving forward, Article 3, Section 2, Clause 2 of the United States Constitution says that when a state is a party in a case involving a citizen, that state, the Supreme Court, has original jurisdiction. The state has a conflict of interest. You cannot unbiasedly represent yourself in the state. The state cannot be a victim. Also, we have been made aware that there is some judicial bonds that may have a monetary value, which clearly gives the state an interest in the outcome of the case. Which once again is why Article 3, Section 2, Clause 2 of the Constitution exists. The state cannot prosecute this because it always going to rule in favor of itself.
If that were even remotely how the legal system actually functioned, we'd virtually never witness a single defendant walk out of a courtroom with a not guilty verdict on the charges stacked against them.
Also, discovery hasn't been met because I was never given a full accounting about the bond relationship in the accounting on the bid bonds, performance bonds. And I am not a 14th Amendment citizen. I am a Michiganian, state national. I have corrected my status. I have spent a year doing it.
What do you mean by that? No, you tell me what you mean by that. I don't need you to look at paperwork. You said you corrected your status, so what do you mean by that?
On finding out about jurisdictions, 14th Amendment citizen is bound by your jurisdiction, sir. I am not a 14th Amendment citizen.
What are you?
I'm an American state national.
And what is that?
That is a man or woman born to the state in the territories of the Confederation of the Republic that made up this wonderful place and all the rights and freedoms that we all have that have been abrogated through policy and procedures.
So are you claiming you're a citizen of the Confederacy from after the American Revolution? And when I say the Confederacy, I mean after the American Revolution and before the U.S. Constitution?
No, sir. This predates even that.
Okay.
I am a living man that follows the Creator's law, the supreme law, the law of the land, which no policy or procedure can abrogate my rights or immunities.
So then how are you relying on the Constitution to say that I don't have jurisdiction if you don't believe that you're subject to that?
Yes.
Supports it.
In the First Amendment, we are one. This is my wife, Jelaine. She's been with me for 24 wonderful years. She has had my back. She has helped me grow and understand and overstand so many wonderful things. The Constitution is set up to protect rights. And I have the right to use everything at my disposal. The Constitution is at my disposal, in addition to the supreme law of the land. So is the Bill of Rights.
The U.S. Constitution isn't a buffet where you get to cherry-pick the clauses that suit you. It's an all-or-nothing package. Either it applies in full, granting you the protections enshrined in the Bill of Rights and every subsequent amendment, or it doesn't apply at all, in which case you'd be stripped of every legal safeguard and could be locked up without so much as a whisper of due process for whatever accusation lands at your feet.
How does the Michigan Constitution play against the U.S. Constitution?
The Michigan Constitution, as wonderful as it may be, is not a constitution. The corruptness that went into it destroyed. Though it may hold some lingering truth, if you change 10% of 100% of the story, you have deceived everyone that you tell that story to. And they will never be able to defend themselves properly. They will never know how to manage themselves properly. If the truth was to be told, then the decision, the rightful will choice would fall on the people. And I am one of the people. Which is why there's also another conflict of interest. The state cannot prosecute me because I am the people. So is my wife, and so are our children.
So it's your belief that the state cannot prosecute criminal laws against its citizens. But if you were a citizen of Texas and violated a Michigan law, would the court then be able, or would the state of Michigan then be able to prosecute that person?
Yes. State of Michigan. The Texas.
No, hold on. It's Mr. Leffers is the one who has.
Well, as I stated,
We are one in our
First Amendment right.
Okay. Mr. Leffers is the one who's before the court. Mr. Leffers is the one who gets to speak on the record.
That would be against my First Amendment right.
He seriously needs to rein her in, because a courtroom operates under strict protocols dictating exactly when someone can and cannot speak. Sure, First Amendment rights still exist, but they don't grant a free pass to override courtroom procedure. If she keeps blurting out interruptions and inserting herself into the proceedings, the judge has every authority to hit her with a direct contempt charge, and that can mean steep fines or even jail time on the spot.
So, Mr. Leffers, you are not releasing any rights that you have, but we're going to reset this then for another probable cause conference next week. And hopefully by then we will have counsel appointed for you, and you can discuss your issues with your appointed attorney.
So I do not accept. Also, I am here on special.
All right, Mr. Leffers,
In the case.
Mr. Leffers, you need to stop. All right. I need you to go out to the front window where you checked in, get a copy of your next court date, because I'm not going to allow you to interrupt the business of the court. And as you can see, you're getting pretty close to that. I'm not saying that you're wrong. I'm not saying that you're right. I'm just saying, again, this is not the forum. That's not what we're here for today. There's a procedure to go through for motions to be filed and to be heard. And as I said, I've appointed counsel, even though that hasn't happened yet, to make sure that you are fully apprised of all the options, the way the court works, the way the laws interact with each other. And I highly encourage you to listen to that counsel, that attorney, once they're appointed. You're not the first one to have this situation before the court. You're not the first one to assert these rights. But there's a way that things work, and your grasp of it right now, I believe that you are mistaken in how the laws interact with each other and how the constitutions interact with each other, how jurisdiction works. So once again, I'm going to ask you to go out to the front window where you checked in. I understand you're not waiving any of your rights, but I'm going to ask you to go to the front window where you checked in and get your next court date, and then we will have, again, we will continue working on getting counsel appointed for you.
Judge asked, it's time to go. No, it's time to go. Thank you, sir.
Thank you.
Have a nice day.
You too.
And that brings us to the close of today's video. My honest suggestion? Next time our friend rolls into court, he might want to leave his ever-talkative better half at home. or wherever their paths first happened to cross. Both of these cases are absolutely getting follow-ups, so stay locked in for those upcoming updates. If this breakdown kept you entertained, smash that like button, drop your thoughts in the comments, and hit subscribe with notifications turned on so you never miss a beat of what's coming next.